Good morning, everyone, and welcome to our real estate table talk with the McIlwain Group. We are so excited for you to join us today. My name is Linda Hurd. We have also a member of our team, Dawn Ferguson. Our also team lead, Janell McIlwain, is getting on. We're short a couple of team members so far. We have Tia Thompson along with Sheila Conti. But we are so excited to have you join us today. We are excited to have Miss Erica Davis with us to talk all things about probate and life estates. And yes, so welcome everyone. Before I introduce Miss Erica Davis, let me give you a little background on her. Miss Davis is admitted to practice before all courts of the state of Maryland, Virginia, and the District of Columbia. Ms. Davis works primarily with estate planning and administration, real estate, foreclosure, and commercial litigation departments. After receiving her Bachelor of Arts degree from Spelman College in Atlanta, Georgia, Ms. Davis then attended George Washington University Law School, receiving her Juris Doctorate degree. She joined the law firm in May 2001 as a law clerk. Upon being admitted to the Maryland State Bar in 2002, she became an associate. With the retirement of one of the founders of the firm, she became a partner and took on full responsibility for Willis Estate Trust and Probate Department. With consummate legal skills and management ability, Ms. Davis has provided her clients personal, effective, and efficient legal assistance. She's an active member in her faith community, and she serves as an officer in her church and multiple ministries. Erica participates in multiple outreach activities to assist those in suburban Maryland, District of Columbia, expanding her basis for professional development and the state same time helping others. Ms. Davis is affiliated with the Montgomery County Bar Association, Anne Arundel County, the Women's Bar, J. Franklin Bourne Bar Association, and the National Bar Association. She's admitted to practice in Maryland, DC, and Virginia. Welcome, Mrs. Davis. We're so glad to have you with us today.
Good morning. Good
Thank
morning.
you.
Welcome.
Good morning,
Yes.
everyone.
Yes, good morning. So, again, our first things first is we would like to open it up to you, and then hopefully at the end, if we have any questions, we can open up for questions at the end.
Sure. Okay. Thank you so much. So I just wanted to first do all the housekeeping, which is first, thank you so much. Estate planning and real estate are my favorite topics. Not only do I handle estate planning when it deals with real estate, I also work with banks and handle foreclosures as well and sell properties through foreclosure. So we do a myriad of things here at the law firm, and we're really excited to have conversations with people about their estate planning, but more importantly, about what's going to happen with respect to real estate. And I am so grateful for the opportunity to be here. I'm just so excited today because this is my favorite topic. I have to do the first part of housekeeping, and the first part of housekeeping is a little disclaimer. The information you obtain by attending this seminar is not intended to be legal advice for your individual situation. You should consult an attorney for advice regarding your individual situation. We invite you to contact us and welcome your calls, letters, electronic mail, but contacting us just for that consultation or quick call doesn't constitute attorney-client privilege relationship. So that starts once you hire a lawyer. Until you hire us, please don't send confidential information to us until that relationship has been established. And so today is for informational purposes, and we hope you can use any of the nuggets that we provide today to be helpful for you, but we just have to do that bit of housekeeping. Is that okay?
Yes.
All right. All right. So is it, I'll just get started, or does anyone want to say anything before I get started?
Nope,
Go
I think
ahead.
we're ready.
Okay, wonderful. Wonderful. Okay. So the one thing that I like to do in these seminars is kind of demystify the process of what is probate. Okay. That's sort of this word that we throw around as lawyers and as people, and we kind of say, oh, probate, oh, this about probate. But here's something you need to know. Probate is different in every state you may live in. So this may be something for the first time you're learning, but the probate process is not a one-size-fits-all process. So it matters where the person lives or normally resides at the time of their death. That's a big, big thing about probate that people need to understand. So when I'm speaking to my best friend in California about a probate process, and I'm here in the great state of Maryland, we're going to have two different situations. So the first thing you want to know about probate is one size doesn't fit all, and it matters where you live at the time of your death, okay? So probate is the process that the legislators for your particular state, they come up with a process where they connect the will that the person may have written, or if they didn't write a will, and they need someone to inform the court that that person has died. So while to us, our loved one's passing may seem like something that we've told people, we've placed it in an obituary, we've had a funeral, the probate process is a totally different, it's a government process of saying, my loved one has died, someone needs to be in charge, and I want to be that someone. Either I have a will, or I'm a part of a group of people that the law says has priority. That sounds like a lot, and that's because it is. So the one thing that we'd like to do when we talk to our clients is find ways to, I used to say avoid it, but I'll say minimize probate or avoid probate. And you may say, well, why do we want to avoid it or minimize it? Imagine doing a process after your loved one has passed. You're dealing with all sorts of other things that come along with your loved one passing, and now you have to go through a lot of paperwork. Now you have to spend some money. Now you have to do things and go back and forth to courthouses filing a lot of information. So to the best we can, before the person has passed, we ask you, or we hope that you'll consider different ways to avoid the probate process. So remember, the probate process is the government getting involved and how things are going to be distributed for your loved one. So you're getting them involved. Avoiding probate is how can we minimize the government involvement. Now you need a little bit because we want to make sure there's no fraud going on. So we do like that when deeds are filed, they're notarized. We do like that there's a public notification of who owns property. That makes sure there's no fraud. So I won't tell you there'll be zero government because you will have to deal with little parts of the systems, maybe land records, but you can try to avoid or minimize probate with a couple of key strategies. So here's the first strategy, and you're going to laugh, but it means something. Figure out what you own. Okay. And that seems like a very small thing, but I always tell my clients, sit down, maybe do one Saturday each, just do a Saturday or pick a day where you're not really doing too much while you're sitting down, just when you're getting ready to binge watch TV, and instead say, wait a minute, let me sit back and take inventory of what I have. Don't try and do it all in one setting. You'll forget. You won't put everything. One at a time. So you want to start with, what are the things that I own? What are the things that my loved ones have told me they put my name on? Those are questions that you want to ask. You have these wonderful parents, and depending on what generation they are from, they're going to be very vocal about what you're going to get, or they're going to be very private. So while you're sitting thinking, okay, these are the things that I'm paying bills on, these are the real estate properties that I'm aware of, you do want to ask your parents those questions. Hey, Mom, hey, Dad, who's on that property that we own in a different county? Who's on that piece of land? Whose name is on that house? So-and-so is living there. Aunt so-and-so is living there. but you may find out, yeah, your aunt is living there, but we never took it out of the name of your great, 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 great grandparent. So the first thing you want to do is take stock of what you have. And it's okay at that point in time to start asking questions to your loved ones about what you may inherit. And this is the best time when you're doing your own planning. So ways to avoid probate. There are two major ways to avoid probate, two major ways. So the first major way when it comes to real estate, the first major way to avoid probate when it comes to real estate is adding people or adding your loved ones to the title of your property. Number one, adding loved ones to the title of your property. When you add someone to the title of your property, you're making or you're starting the process of making that piece of real estate a non-probate asset, a non-probate piece of real estate, okay? Because you're establishing ahead of time what's going to happen at my death outside of a will, outside of needing the government to say who should inherit your property, you're establishing now. So one way you can do that is change the title and add a name, okay? Sometimes people say, well, I really want the person to have it, but I don't necessarily want to kind of relinquish all my rights now. So a lot of my more senior clients say that. So one way we can do that, instead of adding the person's name directly, you can do what's called a life estate. And then list, when I die, this person gets the property. So a life estate would say, and I'm just going to use myself for example, and I'm going to use Linda for example, because that's my eye caught her name. So I'm going to say something like, I, Erica Davis, who own Oak Street property, I am going to give myself a life estate. That means as long as I'm living and breathing, I get to remain in this property. Upon my death, I give the property over to Linda. So the property is Linda's, but she can't occupy it. She can't do anything with the property until I'm actually dead. Okay? So the first way we said was just add the person's name. But some people have reservations because when I add your name, you get a say in the property. When I'm trying to sell it, you get to say, yes, that's the right price. You get a piece of it. But if my intention is I want you to have it when I die, and I don't want this property to go through probate, I'm going to give you a life estate. I'm going to give myself a life estate and then give you the property at my death. So how can I do this? This avoids probate. And so your question is, well, how does that avoid probate? Because at that point, if your name is on the property with the person that died, all you need to present is the death certificate. If you decide you want to sell that property, when you're going to closing, you're not going through probate to go to closing. You're presenting the death certificate. If you're a life estate person, you own the property after the person has died, what are you presenting? You're presenting the death certificate. So I know I have a non-probate situation. If you have questions, guys, interrupt me. I love questions. If you have a non-probate situation, how do I know I have a non-probate situation? Because they're only asking for the death certificate.
So I have a quick question.
As soon as you hear, yes, go for it.
So that is avoiding taxes when you do a life estate.
So let's talk about taxes. So that's a different subject, okay?
Okay.
I'm going to talk about taxes. I love to talk about it, and I hope I don't get in the weeds, but I'm going to talk about it and try and break it down, okay? Okay, so how do I say this? Okay, let me make it fun. Okay, so taxes are different for each jurisdiction that you live in. So that was the big thing I just said. It's going to be different. And when those taxes attach is going to be different. So let's talk about that. So the first set of taxes that most people are worried about are death taxes. You heard the word, death taxes. We're going to have to pay death taxes. We're stressing out because we have to pay death taxes. So death taxes are based on where you live at the time of your death, and there's a federal death tax. So just like we pay income taxes to the state and then we pay them for the feds, same way with death taxes. So that's the first thing we worry about. If you're in the state of Maryland, you pay a death tax if you're passing on wealth to someone other than your spouse of over $5 million. Okay? I have over 5.
Okay. We're good.
Okay, that's just one tax. That's just one tax. So that's the thing. And so everybody laughs because in election season, you know what happens. Everybody's going, oh my goodness, the death tax is going to come. What are we going to do? What are we going to do? Okay. So if I'm in the District of Columbia, because you know I'm triple barred, so I like to talk about all three. And in this, I call it Beltway law. You know, you travel around the Beltway, you own something here, you got aunt here, uncle there. Okay. So then let's go on down the street, and we're in DC. So DC right now is at 4.2 million. So if you die this year, the number is, am I passing wealth over to individuals when I die that are not my spouse, that's over 4.2 million, okay? So if I don't have that issue, I'm not worried about death tax. For any of my wonderful people in the great state of Virginia, the death tax is 0. They don't have it. Yay. So they've got other types of things. You do. You do want to avoid probate. You do want to avoid probate in Virginia. But the one thing that I love to tell people sometimes is, you know, there's, as you move south, so I'm not practicing everywhere down south, but as I've watched, as my clients move south, you're going to see that death tax either be non-existent or have a higher threshold. Okay. In the great state of Maryland, not to get too far in the weeds, you can combine and do special things. Spouse and a spouse can combine their $5 million exemptions to make a $10 million exemption. It's some special things you have to do that. But that's to let you know, those are death taxes. So when you hear the word death tax or estate tax, I'm being taxed because I passed a certain amount of wealth. Now, your federal government, based on the last administration, raised that number, and right now that number is above 11 million, okay? So the concern that everyone's buzzing about is we have a very large constituency in Congress that wants to see that death tax number, the waiver, go down. And there's also an equally large constituency that wants to see it go away or go even higher. And so we don't know. So when it comes to local government, Maryland, I feel secure. Maryland's number was done, I believe, around the O'Malley administration. And so I don't think it's going to change. But if I really knew what was going to happen in politics, I'd be in a different profession. But this is where we are. And I don't know what the federal government is going to do. So those are our big numbers. Are we passing on properties that are over worth over $5 million here in Maryland, over $4.25 million, okay? So then the next tax we have to worry about is inheritance tax, and that is unique to Maryland, inheritance tax. And inheritance tax is about relationship. So when you think inheritance, think relationship. Remember my earlier example about Linda. I think it's okay to tell the viewers that Linda and I are not related, so we would be considered friends. And so if I put Linda as my death beneficiary, I would have to expect that Linda will have to deal with an inheritance tax. That is not something that Linda can avoid with the trust. That is not something Linda can change. Our relationship will always be friends. Unless she adopted me or I adopted her, we would only be friends. That's an inheritance tax. So for people out there that are considering giving property to friends, cousins, niece, and nephews, this tax is unique to Maryland only, where they tax you 10% on the dollar when you transfer real estate outside of your immediate family. There's nothing we can do about it. We can't create a trust for it. It's kind of one of those, it is what it is. When you hear people do very adoptions of very late terms in life, or you hear folks where we'll tell folks that are together, hey, you might want to go ahead and fill out those domestic partner papers if that's what you truly are, or you may want to get married. We have, two people living in a property together, and that's a possibility. Those are things that you can do where you wouldn't have to pay the inheritance tax if you were married to the person or if you were registered as a domestic partner. Okay, so that's inheritance tax. So we have death taxes, looking at $5 million and up, $11 million and up. We have inheritance tax, relationship. Who are you to me? Okay. And then we have another tax that we all, is near and dear to our heart, capital gains tax.
Yep.
So here's the deal. And I'm giving, like I said, there are whole books on this subject. I'm just giving a glossed over so people won't fall asleep on me, kind of understanding. The difference between what the property was worth when I received it versus what the property is worth when I want to sell it. Okay. There is a benefit that you get from waiting. So remember where we talked about doing a life estate instead, where if you wait, or whatever deeds you have, and we'll talk about trust in a second, if things are based on your death, then you don't have to worry about the value that the person purchased the property for, your loved one. You're going to only be dealing with the value as of the date of their death. So what we call, it's called a step up in basis. Okay. So my basis stepped up where or Linda in this case, Linda inherits the property based on my date of death and not based on what I purchased the property for back in the 90s. Okay. So we have 3 taxes to worry about: death tax, gross value; inheritance tax, relationship; and then capital gains or income tax based on how I received the property. So in one of my scenarios, I said, you can avoid probate by adding the person's name. But we want to look at when we added that person's name, because if you added that person's name back in, 2003, and then the person dies in 2023, we got some tax issues. So we want to think about, and this is lots of families, we want to think about, is our biggest concern control and ease of transfer, or is our biggest concern taxes? And that's why I always recommend that people talk to accountants, lawyers, and knowledgeable real estate agents as they make these decisions about what they're going to do. Because there are ways to minimize probate, but you want some advice so that you can figure out, should we do it in a way that we're going to wait until death so I can get that step up in basis? Or this situation has some outside individuals that I feel are going to be a problem, so I'm not so much worried about paying a tax bill. I want to secure that I'm going to be in control of the property when my loved one dies. Okay? And so families, when you're talking to each other, you want to weigh that out. You may have a situation where the lawyer says, if you do it this way, or the accountant says, if you do it this way, you're going to pay some tax. And you may have to say, you know what? We need control over this situation. So I'll take the tax in exchange for the control. Okay? So we did say there were two ways. So the first one was all about playing around with that deed. Okay? How can we do this? Should we do the deed where I add your name? Should we do the deed where we do a life estate? So now here, let's talk about my favorite thing to talk about is trust. So I told you I'm super excited about the subject. It gets me all excited. Trust is about, that's the ultimate control. I know it can be a bummer to say estate planning and planning around this topic of trust and estates. And what I like to do is kind of reprogram your mind, and you want to think about control. Okay? Don't think so much about, this is going to be really sad and this is going to happen and all these other things. What we're saying is, hey, I love my loved ones so much that I want to leave a situation that has order, and structure. So I'm giving some control now so I know what's going to happen. So one way that you can transfer property that I think is the most efficient and best way to transfer property and also avoid or minimize probate is a trust. Okay? A trust is really great. So a trust is where you're going to create what I like to call a situation. Sometimes people say to me, Erica, I need to create a trust. What do I have to do? And I said, well, all you have to do is declare it into existence. And they're like, is it that simple? I'm like, yeah, we got to add some rules to it, but you're just declaring that it exists. Okay? So when you create a trust, I'm declaring a situation, an arrangement exists. That's it. I'm saying that I'm going to put my stuff, my real estate, sometimes other assets that you may have, I'm going to put it into an arrangement. Okay? And if I'm okay and I feel like handling my own things, I'm going to be the trustee. Okay? So you have a trust, which is an arrangement, and I'm going to be the trustee. If I'm okay and I don't have any concerns about me being able to manage my affairs, who better than to control my trust but me? Okay? So what you're doing essentially is, remember we said your family was going to have to go through probate and show the government the documents and prove that they should be in charge? By creating a trust, you're doing all that for them ahead of time. You're saving money. You're eliminating steps. You're making it so all they have to do is slide into your shoes as trustee. So when I create a trust, I allow my loved ones to have a smoother process. They get to be in charge at that time. I also fix that issue of step up and basis, because they're not in charge until my death. So now I don't have that same problem where if I just add the person to the deed. I create a trust. Okay? The next thing I do is I pick up backup trustees. So just in case I lose capacity, meaning I'm no longer in my right mind, or in the event of my death, or, and this one sounds funny, but it's true, I decide I want to go do mission work in a remote part of the world, and I don't want to manage my properties anymore. Just send me an allowance while I'm saving the world wherever. So you can do a trust for a couple of reasons. One, I'm not okay, I'm not well, someone needs to help me. Two, I'm dead. Three, I've decided to not handle my money. I want someone else to do it. So a trust is just an arrangement. So when you have a trustee, that person is a fiduciary. That means that's a person that you believe will take care of things just like you will. Okay? So they're going to know when to sell the property. Even if you're alive, there may be a reason to sell the property. And since they're stepping into your shoes, they're going to have the same rights that you did, fiduciary rights, but the same rights to handle the property. When you have died, instead of having to wait for the probate process, wait for the notices in the paper, wait for the lawyer to get down to the courthouse, wait for the judge to sign the orders, your trustee is able to slide into your shoes, go out, hire a trusted real estate agent to start helping market and deal with that property immediately. You're not losing precious days and time. Okay? A lot of times when we're going through the probate process, I had a slide here, but for some reason I can't find it, and it was my favorite little slide, and I would have shown you, but it's a chaos slide. And in the chaos slide, we have a picture of a family fighting each other, and while they're fighting each other, the property is going into disarray.
Mm.
While they're fighting each other, they're not paying the real estate taxes. While they're fighting each other, nobody is, it literally has a picture of the money flying out the window. Because nobody's paying. Okay?
We have a hand. Looks like Ron has a question.
I don't see a hand.
Ron, do you have a question? I don't see Ron.
I don't see, yeah, I don't see a hand up.
I see a hand. I see a little
You see
hand.
it?
Ron, if you have a question, unmute. Oh, he took the hand down.
Oh,
Okay.
I didn't see it in mine. Okay.
I do have another question. There's another question. So do a trust, does the property have to be paid for, or can you still have a mortgage and put the property in a trust?
I'm so glad you asked that question. Yes, you can put a trust in a property where there's still an existing mortgage, 1, 2, or 3, however many mortgages you have. You can put your property in a trust. And let me be clear, as long as you're putting it in a trust for estate planning purposes, okay? So I know that there's some other colleagues of mine in different states kind of selling this whole, you can avoid a creditor. That's not what we're talking about here. We're talking about estate planning, okay? So if you're moving the property into the trust because you're doing it for estate planning purposes and not to avoid paying your mortgage, right on. You're going to find that most mortgage companies are very progressive about it. They're fine. And just a pro tip, they don't care unless you stop paying your mortgage. So that's when it becomes an issue. So what you want to do is, number one, you need to have your mortgage in good standing, and your real estate taxes have to be paid. And so there's a little bit of a nuance there if you're getting your mortgage, if your mortgage is escrowing your real estate taxes, you know, towards this time of year, your mortgage company is kind of sending it in. So for lawyers, we kind of have to make sure your mortgage company is finished sending in the taxes. Your local jurisdiction won't let you change that title to a trust while the taxes are still due in the latter part of the year. They're not technically late, but your real estate departments of each county, there's some legal ramifications of switching your trust name before the taxes for that year are fully paid. So right after July 1, you have to kind of wait for timing. That's the only thing you have to be concerned about. And I think that's where that misconception comes in, where people say, well, they didn't let me do it because I had a mortgage. That's not what happened.
Okay.
There was a slowdown in the process because your mortgage company has, and rightfully so, they tell you when they're going to pay those escrows for you. And so at that point, you would do it. Now, I don't recommend that people move their property into a trust when the mortgage is super new, unless they get permission. An established mortgage that you've been paying for a year or so is fine, but I do see where, I know we're getting into the weeds of it, where if a mortgage company is selling your loan somewhere else and they go, what did you just do? And so then they're calling you saying, wait, we were just moving your mortgage to X, Y, and Z. Why is it under the name of, you know, Erica Davis Trust now? So you want to have an established mortgage. But the short answer of that question is, yep, you sure can.
So does the trust have to file a separate income tax? So now you get the benefit of paying the income taxes and interest and all that. So does the trust get that benefit and the person doesn't get the benefit anymore if you do that?
These are my favorite questions. The trust is just an arrangement. No, as long as you're still living, your social security number remains connected to that property. You still will file, you and your spouse or you and your whoever are still going to file your taxes the same exact way. You still get your deductions. We're not changing anything. All we're doing, and that's why it's important, all we're doing is creating a situation. All we're doing is creating an arrangement for when I die. Now, when I die, the trust becomes irrevocable because I've died and nobody else can change it. And when I die, my social security number dies with me. You can't use that. So then it needs to have a separate number. But while you're living, it doesn't change. That's not what we're creating here. Remember, everybody, we're creating an estate plan to make it smooth for my loved ones. So, and that's another thing, a reason why people don't want to do trust with me, because they're like, Erica, I don't feel like, you know, creating a business of me. And I'm like, what are you talking about? So these are great questions because these are such common misnomers. And in fact, I've had to start putting it, even though my clients have spent hours with me, I put a reminder to them, do not go out and get you're not a different entity. You're still yourself. Now, when we start talking about people who have rental properties, and you have LLCs, and we're trying to give you layers and layers of protection, your LLC would be a different entity because it's a rental property, it's doing something else. And then the trust would also be collecting those proceeds or the property itself when you die. So that's something separate. But just regular properties that are your residence or regular vacation homes, those properties are not going to change. You're not going to change how you would do your deductions. It doesn't give you any better situation, and it doesn't do worse. It's going to be even. But when you die, you do need a different one. Okay. More questions? Okay.
Mhm.
So just going back to the smoothness of the trust. So the big thing with the smoothness of the trust, remember I said adding someone's name is great, but once I add your name, you get a say in what I'm doing. So now I got this property that I own with Linda, and I want to refinance. And Linda's like, oh, not now. And I go, oh, but Linda, I really wanted to put a basement, finish the basement. And Linda has a say because I added Linda's name. Or I say I want to sell, and Linda says not now. So that's where we say to the client, let's talk about how you feel about control, and maybe a trust is better for you because a trust doesn't lock you in. So this is something important. This is the big thing about trust. Just because you create a trust or a will does not mean that you have to die with any money. I think that people think that you've made a promise forever that the people you listed in your trust are going to get something. You have the absolute right to spend your money however you want, and you could die having given everything away. So nothing about the trust locks you in to having that property at the time of your death. Nothing in the trust locks you in to definitely giving people money. Does everybody understand that? I can still do what I want. So some of people don't do trust planning because they think they're locked in forever. You can have a trust, sell the property you're in, buy a new property, and put that one in the trust. You can still do whatever you want with your assets and your money. Trusts do not lock you in because you're in charge. The big thing is you have to be alive and you have to be in your right mind.
So
Okay?
in the event that, say I put my property in a trust today, and then 3.5 years I'm diagnosed with dementia and I have to go into a home, can the state cause the trust to liquidate to pay for my care? Am I making sense with that?
Yes and no. So if you have a proper estate planning lawyer, and most great lawyers know this, that specialize in that area, they're going to put powers in your trust and in your power of attorney that allow your loved ones to do Medicaid planning. I think that's the question you're asking. So when people say the state put a lien on my house, the state of Maryland does not just walk around like a mean submarine slapping liens on your house, okay? This is about did I need the government to cover my nursing home expenses when I had an asset, okay? And so everybody's answer is going to be different, but this is the one thing your loved ones need to know. Before they start applying for assistance, they should hire lawyers and accountants. It's worth it. Because what happens is they go flying into, we got to do this, we got to do that, we can't handle this, we can't handle that, and they sign everything away before they came up with a proper plan for how to make sure your care could be covered by some of your resources, and how can we also protect and maintain your estate plan. So the short answer to your question is, if your family doesn't do what they're supposed to do, there is a possibility of liens. But if they just take a step back and plan, they can do that. And how do I help them with that? I have a trust, and the trust gives them a plan. If I end up in nursing home care, do this. And my trust will pay for the lawyer and an accountant you need to hire, and they'll tell you what to do. And if I end up in a nursing home, the trust is also going to be complemented by powers of attorney. I'm sure you all have already heard of this, but powers of attorney, what if there's an asset that's not in the trust or something that comes in? My power of attorney would also have the power to organize things for me. So what you do is you set your family up with the power ahead of time So if that time comes, literally your document will say, I do not wish to have my entire assets dissipated by nursing home and other types of expenses. Hire lawyers and accountants to evaluate what should happen. And that is, and that for a lot of people who don't have a plan find that their loved ones' property that had been in the family for years, now they have to sell it when the person dies because there was a lien. But if they had done some planning ahead of time, the lien may have been smaller or non-existent. So the big thing about estate planning is, in my trust or in my powers of attorney, do I give my loved ones the power to hire attorneys and accountants and then make moves for me that protect my plan and protect my assets from being dissipated by nursing home expenses and protect me from taxes to the extent possible.
So once the living trust is it filed somewhere, or does it just stay with the attorney?
Oh, wonderful. So the living trust, the beauty of the living trust, I hope I can tell this fun story. It's not fun, but fun for me. But the living trust is a document. So when you hear about wills, you know the deal. Everybody's going, where's the original will? We got to have the original will. Oh my goodness. Where did they put the original will? Did they put it in the freezer? Did they put it under the floorboard? The thing about wills is that they're great, but they have to be found. And if the person didn't file it with the courthouse, but is somewhere in a house or somewhere we don't know, the will doesn't work like it should because we can't find the original. The beauty of a trust is that you can declare the copy of the signed trust just as good as the original. So you would keep a copy, and yes, if you would like to, you can ask the lawyer to keep a copy. It's every lawyer's choice about whether or not they'll keep a copy because there are responsibilities that come along with that. But you would keep a copy of your trust, and then your first choice successor trustee, they would have a copy as well, okay? Another thing that will say that the trust existed, and this is really good, when we file that deed, putting the property into the trust, that tells people, hey, a trust exists somewhere. Okay? So now I can tell my fun story. This is a fun story. It's fun for me, but the fun story goes like this. I had a client call me, and they had a landlord-tenant matter, and they were very upset. Their parent had died, and they were living. The parent had several properties, and they were living in one of the properties with their large immediate family. And they were very upset because the mother had died, and they said, my sibling has gone to the courthouse and got in charge of the estate. The mother didn't have a will, okay? So the sibling, who was the greediest, who didn't live in any of the properties that the mom had, wasn't allowed to, ran out and got in charge of the estate. So that should give you that should start something in your head saying, wait, I need to have a plan, because that means everybody get in charge. So they were very upset, and they said, I've received an eviction notice from my sibling. And so I said, okay, well, let me come to court and see what I can do. But technically, you got to go. Your mom has died, and it has to be handled. And so everybody said, what did they say? We can't find Mama's will. And since we can't find Mama's will, everything is split even, and your client has to get out the house. And so we had some time before trial. I begged the lawyer, hi, hey, it's Christmas. It's Thanksgiving, I believe it was at the time. Can we please have until Martin Luther King Day? That's all I wanted, to stay in the property. And the lawyer said, no, they want him out. You got to go. And I said, oh, no, this is horrible. This is horrible. So I just so happened, I said, let me just look up the estate. I looked up the estate. Lo and behold, the lawyer was right. There's no will. And I said, let me do a title search on the property. And I did a title search, and there in the title search, it said that my client was living in a property owned by the mom's trust. There's no bill, but there's a trust somewhere. Okay? So I take that deed, and at the bottom of all the deeds, and I'm teaching today, the bottom of all deeds are going to have something like, once you finish with this deed, courthouse, return it to blah, blah, blah lawyer. So I see blah, blah, blah lawyer's name there. And I go, oh my goodness, I wonder if I can get a copy. So I called the recorder of deeds, and just to let you know, the recorder of deeds, your register of wills people are not going to have a copy of the trust. They look at the trust and approve it for recording the deed, but then they trash it. So just to give you an idea, because some people will say, well, doesn't the courthouse have your trust? They do not, okay? They just approved it just for that time being, and then they trash their copy of the trust and record the deed. So I called the attorney's office, retired, not working anymore. Oh no. So we tracked him down in retirement. He's literally, his spouse tells me he's cutting the lawn. I'm like, it's an emergency, call him. And so he says, so I said, hey, America Davis, I found out that there's trust. Do you remember if you have a copy of this trust? And he says, I took all my files and I put them in a storage unit. It's going to cost you blah, blah, blah dollars for me to stop mowing my lawn and go to the storage unit. Sure. So he goes to the storage unit and he tells me, I don't have the original, but the copy says that a copy is okay. Long story short, we got our hands on the trust, and the mom had properly left my client the ability to stay and have that property through the trust. So a will that was lost was just lost, or maybe the person ripped it up, I don't know. But the will was lost. But because that deed mentioned the trust, it was able to bring that back in. So to answer your question, who holds on to the trust, you want to make sure that people who are the trustees have a copy of the trust. And if they have a copy of the trust, should something happen to the original, as long as you haven't put anything in writing where you revoke that trust, you're good. And the reason why it's great that there was no probate process is because now that property that they were trying to evict my client from wasn't even a part of the court process. There was a trust, and only the trust words could control it. So that's a good story of a will gets lost. Even the trust was lost, but because we had a copy of the trust and the trust allowed copies to be used, that's another great benefit to having a trust that you just can't get with a will. When you're trying to probate a copy of a will, all sorts of things can go wrong, and you're making people deal with the court. But if I have a trust, it's smoother, and a copy can be used.
Wow, great information.
Yes. And the benefit of having a great attorney like you who went through all that hard work for your clients.
Right. More of the story always is a title search, no matter what people tell you. Title search is your friend. And have a good abstractor. That's another thing. There's another thing. And so just going back to another benefit of the trust.
We do have one question. One question. I think Sheila Dyson. Did you want to unmute?
Hi. Yes. Hi. Good morning, and thank you. This has been a ton of great information, so I've thoroughly enjoyed it. I've got a 19-year-old daughter, and you've got me thinking a lot about trust, and I'm wondering, would it be wise to do it is there an age limit or a range that you shouldn't put a trust in someone's name?
I love this question. It's one of my favorite reasons to get a trust. The concern we always have is, number one, who should be our trustee? I'm a big fan of waiting until the person is 21 years old to be a trustee, okay? That's one thing. But also, hear me out. The trust gives the greatest protection when the person who is going to benefit from it is not the backup trustee. Hear me out. Mm-hmm. When we create trusts for our clients, we talk to our clients about naming backup trustees that are not the beneficiary, because we can give certain types of spendthrift provisions and creditor protections. And let me tell you why. If I create a trust, and in that trust for my child, I name, let's say, their aunt as the trustee, and my child is just living their normal life and gets into some credit card trouble their first couple of years of college, and now they've got judgments. If something happens to me, and now that they're the trustee and they're in charge of the money, my concern is by the time they get the money I've left for them, it's going to go to those weird debts they got. But if I make the trustee their aunt so-and-so, then their aunt can hold back the money and control how the money is spent so that the money that I worked so hard to save is not going to some, flighty credit card debt that they got. So having the spendthrift provision, protecting my beneficiary from trouble that they got into, requires that my beneficiary not be the same person in control of the trust. So my child's going to get the money, they're going to benefit from it, but they're not going to be in charge of it for those just-in-case moments. Now, some people know that, hey, in our family, we all went to Oxford, we have these high economic degrees, this is our thing, I'm not worried about it, then go ahead and name your child as a trustee, no big deal. But for me, I like 21 and the just-in-case principle, because even if your child is really great with money and things like that, they do this thing called marrying people who are different from them. And the trust helps protect what I call the love factor of everything. And what people do is they say, oh no, my parent has died and they left me an inheritance, and now I'm going to take this check down to the bank and I'm going to put it in our joint bank account. And now I have just made a gift of all my mama's money to this person that we've only been in this marriage for a little bit of time. Marriage breaks up. Marriage breaks up. And I say, give me back my mama's money.
That's right.
And spouse rightfully says to me, you made a gift of that when you put it in our joint account. So another thing that the trust can protect for, it can kind of turn on the faucet of the money, and it gives somebody who has a more sober eagle eye of the situation the ability to slowly turn over the money or do things or give guidance so that the person can remember to keep those assets separate. Okay, that's one thing. And then also it gives time, between that. So to answer your question, can I make my 19-year-old the trustee? Yes, but should you? And that's going to depend. You have better control over your child's benefits of the money if you name someone else, and you want to give your child an opportunity to fully mature. And so I say 21, 25, but even better, the better thing to do is to name someone else as the trustee, and then you put ages. So in my office, we may tell you, why not tell the child when they graduate four-year college or when they're 23, they can start getting quarterly allowances. And at the same time, the trust can pay for their education, maintenance, and support. And maybe when they turn 30, they can have 25% of the trust. And maybe when they turn 35, they can have another percentage of the trust. And then we put a statement in there that says, I trust my trustee to determine if my child is so mature that they can have all the money early. So remember what I talked about, this is all about control. So I like for children to inherit in what I call the faucet concept. You don't give it to them all at once, you turn on the faucet, allow them to mature and get portions of the money to control until they reach the age that you thought that you could handle that level of money.
Awesome. Thank you. Amazing. Very helpful.
And that's the number 2 reason to get trust is controlling your children. I'm sorry, there was another question.
No, go ahead.
Oh, that's the number 2 reason. One thing I didn't talk about, which is like my favorite reason, but the number 3 reason to get a trust is avoiding multiple probates. Can you imagine? So I already told you there's a possibility if you don't have a control over the situation, if you don't have trust or you haven't done something with your deeds, you're going to have to do a probate. But if you have multiple properties in multiple jurisdictions, we do, my Beltway friends, it doesn't feel like it's far because it's right in DC. It doesn't feel like it's far because it's right in Virginia. If you have multiple properties in multiple jurisdictions and you don't have a trust, your family has to open an estate everywhere you own property. So if you have a property in Virginia and DC, but you live in Maryland at the time of your death, then your loved ones have to open up an estate in Maryland, open up an extra estate in Virginia, and open up an extra estate in DC. And if they don't have a lawyer that's everywhere, they're paying for all these different lawyers, all these different court fees. So if you have a trust before your death, you would have a deed that puts the properties all in one trust. So the same person who is the trustee can slide into your shoes without having to open up all the probates and deal with the property. So if you have multiple properties in multiple jurisdictions, it's very, very important you get a trust, or your family doesn't end up with just one probate, they end up with multiple probates. And that's a lot. I do have clients where they're excited to be the personal representative and help their family member, but when I go, oh, they didn't have a trust and there's a property in Georgia, we have to open up a separate estate. And, oh, you're going to need a different lawyer for that. And that's a lot.
Wow. This has been so much good information that we are almost out of time.
Make sure you get a
Oh,
copy.
okay.
Yes, yes, we are. So, Ms. Davis, we cannot thank you enough for all this valuable information you have provided us, from the purpose of a probate deed, how to avoid probate, the benefits of having a trust. This is awesome. Would you like to leave, give everyone your information so they can reach out to you if they have further questions?
Absolutely, absolutely. So it's Erica Davis, and let me give you my email address, and this will be easier for you for our departments. It's estate, so that's ESTATE at A for Apple, W as in William, T as in boy, F as in Frank, law.com. That's estate at awbflaw.com. My direct dial phone number.
You said much better.
I'll put this. Oh, I don't think I can go in the chat.
And you know what? And I will,
Okay.
and if anyone is interested, you can definitely reach out to us. But we had one more question. Would you say, Janelle?
Basically, approximately how much does a living estate, I know it's gonna probably vary depending on how many assets you have to deal with, real estate or whatever, but approximate range that would make it so that at least you could start the process.
Okay, you heard it, Ms. Davis.
Absolutely. So we're going to talk about people who don't need that tax planning. So if you're under that $4 million mark, I'm under the $4 million mark, and I want to do a trust, then that trust is going to run me $3,200. And then there's going to be a fee for each piece of real estate we have to transfer into the trust. So it's a flat fee of $3,200. That's dealing with the trust. And let me also say those powers of attorney would be included with that, and you get a backup will. You still need a will for those just in case moments. So when you pay the $3,200 flat fee, you get a trust, pour-over wills are what they're called, powers of attorney for your health, because we care about you and the money, powers of attorney for your wealth. So you're getting powers of attorney, healthcare and financial, a trust, and you're also getting pour-over wills. The only extra fee you have to pay is that when we record the deed, there's a recording fee that goes to the government. Okay? For those of you who are saying, hey, I don't need a trust, but I want to just do the will process. The will process under the $4 million mark, again, is $1,500 flat. That means I'm doing a last will and testament, and I'm doing powers of attorney, health, and financial powers of attorney. And those are flat fees, so that includes the consultation. That includes going over them with you. I have to see my clients. I'm not one of these, you put it in a computer and we spit something out at you and just tell you to come sign it. We're very strict about meeting with our clients because we want to talk to you about your assets. We want to help you. We want to go through everything to make sure you not only have a plan, but that you understand it. I can't tell you how many people I see and they say, here's my notebook, and they don't know what it means. So it's not going to give you peace of mind unless you understand it. So our flat fees include consultations, revisions, and your final signing day to sign them in our office.
Great.
Sounds awesome.
All right, excellent. Did you want to provide a phone number, your office number, something? I know
yes.
you did your email address, but just in case.
Yes. Yes, we love email, but if you want to call us, 301-738-7685. And we pride ourselves on getting back to our clients within 2 business days of you contacting our office. If we go outside of those business days, we didn't see it, call us back, send us a second email. It's a big thing for us.
Excellent. And Ms. Davis, we will also post this to our website also. So anyone who was not able to log in today, we'll also send them to our website so they can also find out this information, and hopefully get in contact with you with further information.
Wonderful. Thank you so much for the opportunity.
Thank you
And
so
thank you to
much.
everyone who signed on.
Yes, thank you, everyone. Oh, did Ron have a quick question?
I think
see a
she's
hand.
clapping.
Oh, that's a clap. Okay. Thank you. Thank you so much, Miss Davis, and everyone else. And yes, hope you all have a great day. Thank
Bye-bye.
you.
Yeah.